In previous videos in this series, I gave a very high-level overview of intellectual property law, problems, and challenges it presents. We could literally talk about this topic for hours. The amount of references to intellectual property abuses costing the economy billions and hindering startups and small businesses are quite plentiful. And when startups are the biggest job creators in America, anything that slows the entrepreneurial engine down weighs on the entire economy. So how can we fix this? Derek Khanna, a former Republican Study Committee staffer, put out a paper discussing just this very thing. My reforms include his great ideas and expand upon them just a little bit. So to start, we must fix statutory damages. With modern technology the way it is, my smartphone should not make me liable for billions and billions of dollars in damages. Even the courts have felt that up to $150,000 per infringement is an excessive due process violation. And if statutory damages are to be the norm, we need to devise a new system based on, say, ratios or industry or some other algorithm for proper compensation and deterrence. A 99-cent MP3 is very different than a $20,000 piece of software after all. The end result of this change would be twofold: bring sanity back to damages and prevent litigation from being a business model driven by government-granted monopolies. Then we must expand fair use already defined in the Copyright Act. Fair use is intrinsically tied to our First Amendment's right to freedom of speech and expression. So from music to movies, fan fiction, reverse engineering, and more, fair use expansion will further help us promote science and the useful arts. This means more safety and freedom for consumers in how they may utilize goods and services. Everyone wins, except those who don't want any fair use because, it's against their business model. Then we need to punish false copyright claims. Individuals and organizations have abused the Digital Millennium Copyright Act to have content taken down, even if they have no right to take down said content. This has happened with Yelp reviews, public domain photography, music, and more. It's a legal burden of proving innocence instead of guilt because the takedown system assumes guilt by default. And on top of that, we need to adjust copyright terms from the current extremes. I would suggest going back to the original length the Founding Fathers came up with. 14 years plus a 14-year extension. The extension could come with a burden, though, to make the additional years under monopoly protection worthwhile to the public. It's the public who suffers when intellectual property stays out of the public domain after all. The RSC paper also suggests renewal charges based on revenue generated during the original protection term, and I can support that idea as well. It does generate some revenue, and revenue is always good. In addition to those points outlined in the paper, I would propose the following. To start, we must raise the bar on significant differences when it comes to the U.S. Patent and Trademark Office issuing new patents. This alone will combat many vague, obvious, and undeserving patents. No longer would obviousness in prior art be required to be written down somewhere. This would also cut down on the office's patent backlog, on drug costs for non-significant advancements, and a whole lot more. Next, I would give back to taxpayers. Anything produced with taxpayer money would face lessened IP protections. This applies to any document produced by government or government entity, as well as any process or invention that might be discovered through government-funded research, like, say, grants. Currently, under the Bayh-Dole Act of 1980, organizations making use of taxpayer money to develop products for sale or licensing can retain those rights. Now, it's kind of a long story, but know that this solution aims to end that. It's a double taxation on the American people to fund something and then be charged for use of that discovery. I can see two ways to handle this. For anything fully funded by taxpayers, the result would immediately become public domain. Anything partially funded would see shortened patent lifetime, like, say, 5 years to start with no extension or evergreening possible. Note that this applies to universities as well. If a state college funds research, the resulting academic journal articles must go into the public domain instead of being behind some ridiculously expensive paywall. We also need to set up a database of copyrighted works that require mandatory sign-up. Yes, I know this is a bit more government, but I'm not proposing a giant bloated agency. Rather, a simple solution through the Library of Congress propelled by advances in technology. This helps us keep track of what is or is not under protection while allowing us to handle orphaned works better. And if you don't know what orphaned works are, they're works where the owner is unknown, thus preventing us from figuring out if the work is in the public domain or still covered by copyright somewhere. It's a big problem. We do need to address it. Then we need to greatly expand the list of exemptions to the DMCA's anti-circumvention list. This will greatly expand fair use while improving safety and security for everyone. Researchers will be able to do their work without fear of a lawsuit. Those with disabilities may finally get to interact with products they own. For example, if you own an ebook, these exemptions would allow your e-reader to dictate the book to you. Likewise, if you buy a movie, you would be allowed to rip the movie to your phone without needing a restricted ultraviolet copy. Then I would also see software patents eliminated, along with the copyrightability of programming APIs. All software does is execute mechanical or electromechanical actions in the digital realm. It's all process, thousands upon thousands of conditionals lumped together. With it already mathematically impossible to verify your code against all software patents in existence, we don't need companies constantly looking over their shoulders. Patents really should not be shields in the revenue wars. And finally, I want to add some kind of fee-shifting mechanism to the legal process. The average patent defense is over $1 million from start to finish. With a number of lawsuits from non-practicing entities and other organizations who seek to profit or cripple competition, there needs to be a way to fight back without sacrificing everything to do so. Courts can already award legal fees, but they rarely do so. So I want to see more of these fees awarded, especially in cases where it's clearly an abusive Goliath trying to take out a small startup with a patent that honestly should not be granted in the first place. I think these fixes will go a long way to improving how our intellectual property system works. This, in turn, will make life better for everyone. We'll see greater innovation, more creative works, more startups and small businesses, which then leads to more jobs. It'll lower medicine costs, which then help us reduce the federal budget without cutting benefits, and so on, and so on, and so forth. But both parties shy away from IP reform. Both parties really don't want to see it change. Lobbyists especially don't want to see easy money go away. But we must tackle this problem in America. It's the shadow demon responsible for so many issues. You may not have been aware of intellectual property concerns until these videos, but I hope your awareness has been expanded. And I hope together we can tackle this. So thank you very much for watching. God bless you, and God bless the United States of America.